Hello and welcome to Democracy 101 in 5. I am Samson Itodo. On this show, we simplify democracy concepts and bring you information on how you can make democracy deliver for you. Democracy 101 in 5 is an initiative of Yaga Africa with the support of the FCDO. What is arrest and what are the steps in prosecution? As usual, we went to the streets and posed these questions to Nigerians to test their knowledge of the whole concept of arrest and the steps in prosecution. Listen to their responses.
I think the word arrest means being detained for a certain crime.
When a police officer came to arrest you because you committed a crime.
A policeman coming to detain suspects, to ask him few questions and the rest.
It's always interesting to speak to Nigerians on the street. Section 35 and 36 of the 1999 Constitution as amended provides reasons why a person will be arrested. And the Constitution says that every person shall be entitled to his or her personal liberty, and no person shall be deprived of such liberty except when he or she commits a criminal offense and that he or she has been found guilty of a crime established by law. The Constitution also provides that any person who is arrested or detained shall have the right to remain silent or avoid answering any question until after consultation with a legal practitioner or any person of his or her own choice. The Constitution also says that any person who is arrested or detained shall be brought before a court of law within a reasonable time. And if he or she is not tried within 2 months from the date of his or her arrest or detention, in the case of a person who is in custody or is not entitled to bail. Also note that any person who is unlawfully arrested or detained shall be entitled to compensation and public apology from the appropriate authority or person. And in that subsection, the appropriate authority or person means an authority or person clearly specified by law. It is essential in a democracy that everyone has the opportunity to present their case before an impartial tribunal or court. This means that a court or tribunal must be independent, must be impartial, and that the trial must be conducted within a reasonable time. Every person who is charged with a criminal offense shall be presumed to be innocent until he or she is proven guilty. No person shall be held to be guilty of a crime or offense on account of any act or omission that did not, at the time it took place, constitute such an offense, and no penalty, based on provisions of the Constitution, shall be imposed on any criminal offense heavier than the penalty in force at the time the offense was committed. In other words, a law or penalty for a crime cannot have a retroactive effect where it is applied to those who committed the crime before the law came into existence. No person who shows that he or she has been tried by any court of competent jurisdiction or tribunal for a criminal offense, or either convicted or acquitted, shall again be tried for that offense. No person who shows that he or she has been pardoned for a criminal offense shall be tried for that offense. The Constitution is also clear that no person who is tried for a criminal offense shall be compelled to give evidence at the trial. A person shall not be convicted of a criminal offense unless that person is defined and that the penalty, therefore, is prescribed in a written law. And in this subsection, a written law means an act of the National Assembly or a law of a state, or any subsidiary legislation or instruments under the provisions of a law. Now you know as a citizen what is arrest and the procedure for prosecution as established by our Constitution. That's Democracy 101 in 5. We would love to hear from you, and so you can reach us on any social media platforms via @Yaiga. You can also watch this episode and other episodes on our YouTube channel @Yaiga1. Thank you for watching. I am Samson Itodo. As always, remember, you have the power to make democracy work for you. Please use it wisely. See you next time, and bye for now.